Hi, this is Brian Ka with another video to help you pass the California baby bar exam and the bar exam. So in this video, we're gonna cover another wills and trusts question from February of 2018, and this is question 5. So let's read the call of the question as usual and see where this takes us. So here we have what rights, if any, do Nell, Ann, Bob, Carol, and the start employees have in Ted's estate. So Nell, Ann, Bob, Carol, start in Ted's estate. So we have all of them here, 1, 2, 3, 4, 5, and we're trying to find out what rights each of them have uh, in Ted's estate, which is here. So let's read the fact pattern and see what we get. So in 2001, Ted, who was married to Wendy, signed a valid will bequeathing all of his property as follows: 10,000 of my separate property to my daughter Anne, then 2,000 of my separate property to each person who is an employee of my company Start at the time of my death, and all the rest of my separate property, plus all my share of our community property, to my beloved wife of 20 years. If she survives me, no other gifts were specified in the will. Okay, so we have 2001 will, right? 10,000 to the daughter Anne from separate property, 2,000 each to Start employees, right? And at the time of his death, all of the rest of his separate property, plus all my share of our community property, right? So, rest of SP and rest of CP community property goes to um, his wife, right? And the will doesn't uh, specify the name of the wife, but I guess through, you know, extrinsic evidence, um, probably refers to Wendy, but I'm just going to make a mental note here to myself. Okay. But this is conditioned on the fact that if wife survives Ted. So this is a conditional language, which means that if wife dies before Ted, this will on rest of separate property and rest of CP will not go to wife, but instead will probably go to intestate succession, right? Okay, so in 2003, Wendy dies. In 2005, Ted adopts uh, Bob. And in 2006, he signs a codicil to his 2001 will, stating that he's going to bequeath 10,000 to Bob and rest stays same. Okay. So in 2011, Ted marries Nell. In 2012, Ted and Nell had a child, Carol. Okay. In 2016, Ted dies. And he left his 2001 will and his 2006 codicil as the only testamentary instruments. And after all debts, taxes, and expenses had been paid, Ted's separate property was worth 90,000. So he had separate property worth 90,000, and his share of the community property was worth 100,000. 100,000. And at death, Ted still owned Start, which by then had 10 employees, none of whom had been an employee of Start in 2001. Okay. All right. So the first person, Nell, right? Let's write Nell here. And Nell is someone that Ted married in 2001, right? Uh, Ted marries 2000, uh, 2011, not 1, 11. Now, the issue here is that first, um, in a valid codicil to his 2001 will, stating that I hereby bequeath $10,000 of my separate property to my beloved son, Bob. All the rest of my 2000 will remains the same. But if you look at 2001 will, um, there is a conditional language stating that um, all rest of separate property plus all community property goes to wife if she survives. Now, did she survive? Well, Wendy died in 2003. So, what happens to this gift is that because there was a conditional language saying that she had to survive Ted, this language of rest of SP and all of community property fails, right? I hope you understand why it fails. Um, Now, there's an argument that I guess you can make, um, saying that there is an anti-lapse statute, right? Meaning, um, since this gift lapsed, since she wasn't available, um, she's not eligible to receive the gift. However, this is not the issue that we're dealing with here. Because there was a conditional language stating again that wife has to survive uh, Ted in Ted in order for her to get the rest of SP and all of CP. There's no not real no lapse or anti-lapse argument to even make, right? Because if the condition fails and it's not satisfied, then there's not even a need to go into a lapse or anti-lapse statute, which bequeaths uh, whatever was supposed to go to uh, the person, the beneficiary receiving it, but it goes to the kindred, right? That's the anti-lapse, right? Meaning issue, blood related issue. But this issue won't even be discussed here since that conditional language wasn't triggered, meaning she didn't survive TED. So that means that this rest of SP, all of CP going to wife if she survives TED, fails completely, right? So if that fails, and Nell has no argument to make there. What she can do next is that she can say that she was a omitted spouse, right? Meaning, if you're an omitted spouse, that means after the testamentary instrument was created, she wasn't provided for. In here, in 2006, there was a codicil, right? Willing to his 2000 will, one will, saying 10,000 of his separate property to Bob, and everything remains the same, right? In this codicil, um, obviously Nell wasn't provided for because in 2011, 5 years after 2006, that's when Ted marries Nell, right? So after Ted married Nell, that codicil or will wasn't updated. So that means that under omitted spouse doctrine, first she becomes an omitted spouse. And again, she's an omitted spouse because the last codicil was in 2006. Ted married Nell in 2011, and she wasn't provided for in Ted's will, and or Ted didn't update the will to include his wife. That means she is an omitted spouse. Now, when you're an omitted spouse, that means the property goes into intestate succession, meaning community property, right, goes to the wife. Now, as for separate property, um, the entire separate property that Ted had was 90,000, and because he had Ann, Bob, and Carol as kids, it means the wife gets 1/3, and the rest of 2/3 get distributed to the children, and they can divide that themselves, right? So here, what we end up with is that Nell gets all of CP, $100,000 share of Ted, and she also gets 1/3 of Ted's separate property, which is 90 divided by 3 is 30,000. So that takes care of Nell. Now let's talk about Anne. So Anne was provided for uh, in the 2001 will, and she was to be given 10,000. So let's write 30,000 here for Nell, 10,000 for Anne. Um, and other than that, the 2006 codicil, does that revoke Anne's 10,000? Because revocation requires intent to revocate plus physical act, right? Here, when Tet signed the valid codicil to 2001, uh, so the codicil was written in 2006, but he's referring to this 2001 will. The language it said was, I hereby bequeath 10,000 of my separate property to my beloved son Bob. All the rest of my 2,000 wills remains the same. So Anne's 10,000 doesn't get revoked. It wasn't even discussed here, right? Because this codicil was basically an addendum. So we have no revocation of Anne's 10,000, and she gets to keep $10,000. Now we gotta do Bob. So in uh, 2005, we have a child, Bob, whom Ted adopted, right? This is 2005. Ted adopts Bob. Now, in 2006, will he provided Bob with $10,000. Now, Bob can try to claim more by arguing that he's an omitted child, that he wasn't provided for in the will, and that Ted didn't have knowledge of his existence. Those are the elements needed to establish that one is an omitted child. But since um, he knew of Bob's existence, and he even uh, provided for Bob in this 2006 codicil, he doesn't qualify as an omitted child. And obviously, when you talk about omitted child, there are three exceptions. First is when you're provided for uh, outside of the will, when you're intentionally excluded from the will, and also if the will provides for Bob's parents somehow, that's another exclusion. But here, it's clear that Bob is not an omitted child, and that argument will fail. So, what does Bob end up with? Bob ends up with $10,000, right? Now, um, here we have two more. Carol. Now, is Carol, who is Carol? Carol is when Ted and um, Nell married, they had a kid 1 year after in 2012, and Ted and Nell had a baby named Carol, and that's who this is. And now, since she wasn't provided for in the will, because the last codicil that Ted wrote was in 2006, and Carol was born in 2012, she wasn't provided for, right? So she has an argument for being an omitted child. And again, you have to look at three exceptions. If if she was provided for outside of the will, then she doesn't qualify. And here she wasn't provided outside of the will. If Ted left something, um, if Ted intentionally excluded um, Carol from uh, the will, then she doesn't become an omitted child. The third is um, if Ted provided for her parents, which would be Nell in this case, she wouldn't qualify. But Nell, as we've discussed already, got 30,000 out of intestacy. Not that she was named in the will. So that these three exceptions, they don't qualify, right? So as an omitted child, out of 90,000, after uh, giving 1,000, 90,000, 30,000 to Nell, and Bob. So calculation goes 90,000, and because she gets one third, and becomes 60,000, and becomes 40,000, and from that, um, so she's gonna end up with 20,000, right? Because from 90,000, we have 30,000 for Nell, 10,000 to Anne, 10,000 to Bob, and 10,000, 20,000 to Carol. And lastly, we have this company Start. And since there are, uh, how many employees were there? 10 employees, and 10 times um, 2,000 would be 20,000. Only thing that would possibly block these Start employees from getting uh, $2,000 each is if there's a doctrine called um, not DRR, but what was it called? Facts of independent legal significance, meaning if the Star company would have existed even without this will, then they would be eligible to get these $2,000 each. If not, um, they would not be eligible to get these 2,000. Now, the Star employees, this company was set up way before the company here, according to the facts. It was mentioned in 2001, so that company would have survived even without this will. So this is a fact of significant uh, uh, fact of legal significance. This is not easy. Facts of independent legal significance. So that because this was a fact of legal independent significance, it's not going to stop 20,000 from being distributed. So here, this 20,000 will end up going to Start, which means that 30,000, 10,000, 10,000, 50,000, 70,000 after Carol, and 90,000, all the money gets distributed. CP goes to Nell. So that's how this question ends up being distribute it in the end. I think that I struggled a little bit with facts of independent significance because I think that was like tested like just once in the previous exam. I think it was the last one we did, and I don't think I practiced it enough. But again, doing this in front of the camera, under pressure situation, trying to talk about this, fortifies my uh, skills and whatever my weaknesses is, it gets exposed. So what do? I'm just gonna keep practicing and keep reviewing so that I can get better. But this definitely was one of my weakest essays, which means that I'm probably going to um, go over it like 3, 4 times again until I can completely understand it, and to make sure that I don't forget the fact of, you know, significant legal, I can't even say it, facts of independent legal significance. Make sure I need to drill that in my head. So I think being real instead of looking at the notes to do this is good practice, because first you're gonna see me struggle, and second, um, when you see me struggle, it means this is not something that's an easy essay. So which parts are going to be tricky, which parts you might have to review again. And even for me, instead of re-recording this video and trying to make it perfect, I think that it's rather beneficial for me to just upload this and show you where I struggled, and from that I'm going to try to make improvements and make sure that when this type of question comes around again, that I can, do a lot better and remember all these nuances so that I can get a passing score on this type of essay. So with that, I want to thank you for watching another video, and I'll see you next time.